Welcome to my channel, All for Health with Jane. Greetings, family, and a happy 2025. Sometimes last year, in 2024, 5 of the 7 accused in the AKA and Tibz murder case were denied bail in the Durban Magistrate Court. After this denial, because they were not satisfied, they approached the High Court for an appeal. The High Court ruled this appeal unsuccessful. In January 2025, that is on the 9th, we see 2 of these 5 accused in the Durban Magistrate Court having refiled a new bail application on new facts, hoping that this will get them out of jail. Represented by Advocate Simpiwe Mlotshwa, the 2 accused are Mziwethemba Kwabeni, who is applicant number 1 in this matter, and Lindoku Ndimande, who is applicant 2. They are accused number 4 and 5, respectively, in the AKA and Tibz murder case. Remember, family, that as all these happened, the other 2 Ndimande brothers are still kept in Eswatini, still going through processes of their extradition application. Family, let's watch and listen as Magistrate Vincent Hlatshwayo is explaining the procedures and conditions of this bail application.
After this court granted its judgment on the 15th of May 2027 refusing bail, the applicants in this matter have approached the High Court on appeal before they brought the renewed bail application on new facts. The High Court had their appeal and ruled that the appeal was not successful. The question that arises now is that can these applicants come back to this court on renewed bail application on new facts? Put differently, should these applicants be allowed to bring a renewed bail application on new facts under these circumstances? If so, in terms of which section? If this court entertains such an application and find that there are indeed new facts that are exceptional and justify their release on bail, what is going to happen to the judgment by the High Court? Can this court review and set aside the judgment of the High Court? If this court finds that there are no new facts that are exceptional and justify their release on bail, can they go back to the High Court and say what to that court, which have already made a ruling in this matter? This is indeed absurd, and maybe that is the reason why there are procedures. In any event, I've had the application because my view was that perhaps, in all fairness, doors should not be shut in the face of the accused person who has been advised and believes such an advice that he has a case. In this application, it is applicant 1 and applicants 2 contention that since the last judgment, there are new facts that have since come into being. These facts, according to them, are exceptional and they justify their release on bail. It is the applicant's assertion that since the unsuccessful bail application, there has been new facts and change in their circumstances that are exceptional. Guided by the above-mentioned guidelines and principles, such circumstances warrant and justify their release on bail. Both applicants allege, 1, that since the refusal of bail, the prosecution informed this court that the investigation are now complete in this matter, which stands to reason that there is no fear of interference with the witnesses. 2, the extradition process of the 2 Ndimande brothers is still not finalized due to its inherent intricacies and complexities. This is contrary to the state's stance during the initial bail application that they will be joined in this matter sooner than later. After the refusal of bail, this matter is still on the district court roll and not yet transferred to either the regional court or the high court in terms of section 75 of the Criminal Procedure Act 51 of 1977.
Family, after Magistrate Vincent Hlatshwayo has dealt with the challenges, the confusion, the contradictions that are caused by this bail application, let's look into the reasons that are given by these two applicants as there are new facts or information. Not forgetting that these two applicants both promised not to interfere with the witnesses should they be granted bail. Starting with Mziwethemba Gwabeni, whom the police say he is allegedly the mastermind in this case. Gwabeni says his mining and construction business is suffering while he is in jail. This is reason number one that he is giving. Then the next reason he is saying the child's school fees is not paid, which will lead to the child being expelled. Family, remember in the initial bail application or bail hearing, Gwabeni said he's owing the school something like 100,000 that needs to be paid. Now he's saying because the business is not functional when he's not there, the child might be expelled for him not being able to pay the 100,000. And number three says the school fees for another minor child is also falling behind. Number four, he says one of his children had to attend counseling in August 2024 due to the stress that is being caused by Gwabeni's arrest. The child had to undergo some counseling. This is what Gwabeni is saying. Then the fifth reason that is giving, he says one of his wives, remember, Gwabeni has about 3 wives. Now he says one of his wives had to go for therapy because of the traumatic experience that is caused by his detention. Applicant number 2, who goes by the name Lindogu Hlandimande, Yena, he says the only taxi that he has was involved in an accident and was since not repaired due to his incarceration. Because of this, his family has been going through major financial challenges since this taxi was the main source of income. So he's saying the taxi needs to be fixed, and because he's not out there to do it, his family is facing a major financial challenge. Family, let's watch and listen as Magistrate Vincent Hlatshwayo explains to the court these reasons.
In addition to these facts which are alleged by both applicants, applicant number 1 further alleges that one, after the refusal of his bail due to his incarceration, St. Benedict School sent his family a letter of breach of contract and alleges that in the event 100,000 is not paid by the 10th of December, then the contract will be terminated. 2, after the refusal of bail, one of his minor school-going child had to attend counseling since August 2024. 3, after the refusal of bail, the school fees of his other minor child fell into arrears at Grace Place. 4, after the refusal of bail, his junior wife had to seek therapeutic treatment because of the traumatic experience she underwent. In his case, applicant 2 further alleges that after the refusal of his bail, the only taxi he has was involved in an accident and has not been repaired due to his incarceration. 2, after the refusal of his bail, applicant number 2 and his family have suffered extreme financial prejudice as he has not been able to conduct his employment duties and therefore generate income to sustain his household. Both applicants claim that the facts referred to above are different in character and constitute new facts that warrant consideration in the interest of justice. They have both annexed relevant documentation in support of their respective assertions.
Family, to be honest, if you are following this case, you will realize that all these reasons that are given on the 9th in this court, they are not new facts at all. Because everything that has been said on January the 9th in this court is what we have heard in the initial bail hearing. But the two applicants claim that these are new facts. So in response to this application, the state is opposed to it and has verified the allegations by these two applicants. The school fees issue, which was raised in the initial bail hearing, the state says it can therefore not be used as a new fact. As per the investigating officer's evidence, the issue of the child attending counseling in August 2024, it's got nothing to do with the incarceration of his father, who is Mziwethemba Kwabeni, but it had to do with the child's concern about his mother, who was not well. In terms of applicant number 2's car, that he says needs his presence to be fixed, the investigating officer says the car was since broken last year, May 2024, and appeared abandoned. They found it somewhere. The car looked like it was abandoned. It didn't look like a car that was very important in the lives of applicant number 2 and his family. He says if it happened in May 2024, it means this was long before the initial bail application, and it was obviously used as a reason in that matter. Family, let's watch and listen.
The state is opposed to the application. In this regard, the state has verified the alleged new facts and filed an affidavit with annexures by the investigating officer, Warrant Officer Pillay. In his affidavit, Warrant Officer Pillay, the investigating officer, deal with each applicant individually and separately. For purposes of this judgment and brevity, I will, where the facts are the same, deal with them together and jointly. It is the evidence of Warrant Officer Pillay that inasmuch as the investigation has been completed, the concern about the safety and well-being of the witnesses is of much concern, even more so now that the identity of the witnesses will be known. Regarding the Eswatini High Court judgment, it is the state's contention that it undertook to proceed without the Ndimande brothers if the extradition process is delayed. The state further contends that inasmuch as the matter is still in the district court roll, but it will be transferred to the High Court on the 7th of February 2025. Regarding applicant number 1's assertion pertaining to school fees, Warrant Officer Pillay states that this fact was raised by the applicant during the initial unsuccessful bail application and refers the court to paragraph 58 of Exhibit F, that is applicant number 4's founding affidavit in those proceedings. It is therefore the testimony of Warrant Officer Pillay that what Mr. Kwabeni, applicant 1, is stating herein cannot be said to be new facts because it was raised during the initial unsuccessful bail application. Warrant Officer Pillay goes on to dissect this as per annexures NF2 and NF4, which were submitted as annexures in support of applicant 1's testimony. It is further the evidence of Warrant Officer Pillay that the fact that the minor child attended counseling had nothing to do with the incarceration of applicant number 1, but the concern was about his mother, who was, according to the minor child, dying. He further testifies that the fact that the wife of applicant number 1 attended therapy on the 4th of March is not a new fact, as this fact happened before this court pronounced itself on the unsuccessful bail application on the 15th of May 2024. It is his evidence that it was this very wife, or this very wife even testified in that bail application by filing an affidavit, which affidavit was commissioned and submitted on the 19th of March 2024, but never mentioned this fact, yet this fact was available and known to her and the applicant at that time. Warrant Officer Pillay went on to testify about the strength of the state case, alleging that the state has now secured CCTV footages at the King Shaka Airport for the day of the incident when the deceased, Mr. Forbes, arrived at the airport. He elaborates as to the content of the footage and the detail what is seen in there. According to him, there is a clear involvement of applicant 1 as the organizer, and the fact that he played a lead role in the hit. In his testimony, Warrant Officer Pillay further challenges the allegation by applicant 1 that his release on bail will afford him an opportunity to raise fees and consult as an old but reshuffled fact which was raised and dealt with in the initial unsuccessful bail application. Regarding applicant 2's assertion that the only taxi he has was involved in an accident has not been repaired due to his incarceration, Warrant Officer Pillay testifies that this fact was followed on the 6th of January 2025, and certain individuals related to the applicant, he mentioned them by name, were consulted and interviewed in this regard. The leads that were provided by these individuals were followed, photos of the taxi in question were taken and handed in as proof of that fact. According to the brother of applicant 2, the incident happened on the 18th of May 2024, but was not reported to the police as there were no injuries. The vehicle in question was found in an open space or field some distance away from the houses, and it appeared abandoned. This was after Warrant Officer Pillay had been to Camperdown and was referred to Durban, where he could not find the vehicle, but he later found it at Umkomazi area. He raises his concern and questions in this regard, given the nature and caliber of the assets and other assets. This court has had arguments and submission for the granting of bail on behalf of the applicant by Advocate Hlatshwayo, and the counter-argument and submissions by Advocate Gaba for the state. And this court has to pronounce itself on this evidence.
Family, after Magistrate Vincent Hlatshwayo has summarized this matter, he finds himself agreeing to the state and the investigating officer, Mr. Pillay. Family, let's watch and listen as Magistrate Vincent Hlatshwayo is giving a ruling over this matter.
It is tried that an accused person has a fundamental and constitutional right to apply for bail and be released on bail if the circumstances and the dictates of evidence so demand. It is, however, an abuse of the process and proceedings to allow an unsuccessful bail applicant to repeat the same application for bail on the same set of facts week in, week after. This was the line of reasoning and the finding by the court in the matter of State v. Fermas 1996, Volume 1, SACR 528, Transvaal at page 531, paragraph E. The court may also not, in the absence of new facts, justify granting of bail set aside its own earlier decision of bail or of refusal of bail in this regard. And in this regard, see the matter of State versus Waldeck, 2006, Volume 2, SACR 120, Northern NC at page 53. In this matter, I've heard the evidence, whether correctly or wrongly, and I have to make a decision on whether the facts presented before me amount to new facts and therefore justify the release of the accused on bail. I've set out and summarized the issues as well as the facts that are alleged to be new and outline those that are common to both applicants and dealt with them together and jointly, and those that are peculiar to and pertain to each applicant separately. It is the judgment of this court that whereas Section 60, subsection 4C of the Criminal Procedure Act 51 speaks of the likelihood of interfering with witnesses, this court had the actual interference with the witnesses who were known to applicant 1 at the time by applicant 1. So the issue of interference or non-interference with witnesses is not a new factor, but this court dealt with that in the initial bail application and found that applicant 1 will not hesitate to interfere with witnesses that implicate him, as he had already done in that case. It is therefore the finding of this court that that likelihood is still there. We are still dealing with the same person. And on the evidence before me, there is nothing to suggest that applicant 2 is different or will act differently. The issue regarding the Eswatini High Court judgment, it is the finding of this court that that is neither here nor there. It does not impact on the bail issue in these proceedings or subsequent proceedings simply because the state committed itself to proceed with the matter with or without the two Ndimande brothers in Eswatini, who are the subject of Masuku J's judgment. It was the state's commitment that in as much as proceeding with the matter without the two Ndimande brothers will come with a potential prejudice to the witnesses who will have to testify twice about the same subject, it is the prejudice that they can live with. It is a fact that this matter is still in the district court roll, but it is common knowledge to anyone involved in this matter or anyone that follows the proceedings herein that as on the 29th of November 2024, the state placed on record that the application for postponement was for the indictments to be served on the accused on the 7th of February. So as the matter stands, in as much as the matter is still in the district court, but it will be transferred to the High Court on the 7th of February, when after the accused have been served with the indictments. So this cannot be a new fact. Regarding the issue of St. Benedict School sending a letter of breach of contract in the event 100,000 rand is not paid by the 10th of December and the payment of school fees at Grace Place, I must unfortunately agree with the assertions by Warrant Officer Pillay and the argument by the state that this matter was raised and dealt with in the initial unsuccessful bail application. Moreover, as it would appear on the papers, applicant 1 made an undertaking to honor the payment when he was in custody in this matter. Looking at the issue that pertains to children, one may tend to be sensitive to say that there are children involved and one has to promote the best interest of the children. It is my view that the best interest of the minor children, as stated in Section 7 of Act 38 of 2005, are not undermined in that both biological parents have the rights and responsibilities in respect of these children. Although applicant 1 is incarcerated because of the allegations made against him, there is still an able and properly qualified mother who is a medical doctor that looks after the well-being of the children in the absence of applicant 1. There is therefore no question of these children being the children as described in Section 150 of the Children's Act 38 of 2005 as children in need of care and protection. According to the papers before this court, the wife of applicant 1 attended a therapy on the 4th of March 2024. An asset that generates 20,000 rand per month is an asset that is valuable to its owner and those who benefit from it. Common sense dictates that such an item will be well looked after. Steps will be taken to look after it and protect it from some eventuality that may befall it. This will be more so if the owner thereof is a person that earns well to fortify and confirm his empire, but not simply abandon such a valuable item. In this case, applicant 2 tells this court that his taxi that generates 20,000 rand per month for him and his family was involved in an accident which was never reported to the police because no one was injured. After such an accident, which was never reported to the police, the vehicle concerned was abandoned for the wreck to rot up. With the greatest of respect, this does not make common sense. This fact, coupled with the evidence of Warrant Officer Pillay that on the 6th of January 2025, the information regarding the vehicle in question was followed, and after they were sent to Durban by people he mentioned, they eventually found the vehicle at Mkomazi at a place that belonged to the brother of accused 2, Zenzele Ndimande, leaves one with doubt as to the veracity of this. Even more so when applicant 2 alleges as a new fact that he and his family, after the refusal of bail, have suffered extreme financial prejudice. Looking at the evidence in its totality, it is the view and finding of this court that the financial prejudice referred to by applicant 2 is self-created for him to allow such a valuable item to rot up. And it does not amount to new facts. And looking at the totality of evidence, it is the finding of this court that this court cannot and this court should not assist the applicant because the facts presented before this court are either not new and they should not be entertained, and applicant's application to be released on bail is again refused. Gentlemen, the matter against you is postponed for indictments until the 7th of February. You are both to be kept in custody.
Family, in conclusion, bail was not granted, bail was denied again. In the comment section, family, let's talk. Do you think it's fair? The magistrate did not give them bail again. Let's talk about it in the comment section. And family, the trial for this court is will be starting on the 7th of February. So 7th of February, we are starting with the trial of this case. Thank you very much for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet, family. I love you. Thank you. Bye.